Good afternoon, everyone, and welcome to our webinar entitled E-1 and E-2 Visas for Traders and Investors. My name is Avi Friedman. I'm a senior attorney with Wolfstorff Rosenthal, LLP. We are based in Santa Monica, California. We also have offices in New York City. You can see my contact information on this slide. It's very simple. It's Avi, A-V-I, at wolfstorff.com. We also have a toll-free number, which is 800 Visa Law, V-I-S-A-L-A-W. And you can check out our website at wolfstorff.com. So also, if you have questions during the presentation, there is a panel that you could submit your questions, and I'll be able to look at that and either discuss it while we go through the presentation, or at the end we'll also have some time to take your questions. And if you have questions that arise later on, you're always welcome to give me a call in the office or send me an email as well. So let's start off by talking about what is an E-1 or E-2 visa. And basically, these are two classes of non-immigrant visas based on treaty relationships between the United States and other countries, and that's established in the Immigration Act and in the Department of State Foreign Affairs Manual. The E-1 refers to treaty traders, someone that's going to be carrying on substantial trade, such as trade in services or technology, which will be primarily between the United States and the treaty country. The other category is called the E-2, which is a treaty investor. This would be someone coming to develop and direct the operations of an enterprise in which the national has invested, or they're in the process of investing, and it needs to be a substantial amount of capital. In terms of the E-visa requirements, I broke it down into four basic requirements. One, there needs to be the existence of a treaty. There needs to be, for the applicant, they must possess the nationality of the country that has the treaty. For the E-1, there must be substantial trade. For the E-2, it requires substantial investment. And the person coming in on the visa must be coming to work in a qualifying capacity. And we'll go through each of these requirements in a little bit more detail throughout the presentation. So number one, in terms of existence of a treaty, you can apply for E-status as long as you're a national of a foreign country with which the United States has one of the following. And it's going to be either a treaty of friendship, commerce and navigation, a comparable bilateral investment treaty or BIT, or other multilateral trade agreements, such as the NAFTA agreement, which is the treaty between the United States, Mexico, and Canada. The next concept is nationality. So the applicant who's going to be applying for the E-status must hold the same nationality as the treaty country. And normally nationality will be determined by the laws of the treaty country, and it generally follows the applicant's citizenship. If you want to see a list of countries that have treaties with the United States for the E-visa purposes, you can take a look at the Department of State's Foreign Affairs Manual at the following link. Also, you could search for online, just do a quick search of E-visa countries. You probably end up with the same link. There's approximately 80 countries or so that have treaties with the United States. Most of the Western European countries have treaties with the U.S., many Asian countries, Middle Eastern countries, but not every country does have a treaty for the E-1 or E-2, and some countries have just the E-1, others just the E-2. Really depends on what's been established between the United States and the other country. There is talks about establishing treaties, an E-2 treaty with China. Surprisingly, we do not have an E-2 treaty with India or Russia. There are E-visa treaties with some countries like Pakistan and Iran, and right now we're in the works of the U.S. has passed the E-2 for Israel, and we're still waiting for the Israeli government to ratify their end of the agreement to grant the equivalent to U.S. nationals. So if you're interested in seeing the list, just click on that link. You'll be able to view and see if your country might qualify for E-1 or E-2 or both. Real briefly on the E-1 visa, there's the concept of substantial trade. And what that means is the international trade must be substantial in the sense that there's a sizable and continuing volume of trade. As mentioned, the trade must be principally between the United States and the treaty country, which means more than 50% of the international trade involved is between the U.S. and the country of the applicant's nationality, or the treaty for the company. Volume is more important than the value, so the more trades in an annual basis is going to be more important than just the value of one big trade. Trade has to be in existence, not just in progress, not in theory. The trade must have occurred. And trade can include goods or services which are exchanged in the international market. A couple examples of actual E-1 visas that we've done for folks include, for instance, we had a national from France, and we were able to do an E-1 based on importation of French wine and distribution of French wine in the U.S. We had a client from Israel who imported Israeli agricultural products. The goods could be anything, and it could be import or export. It's just the majority of the trade must be between the United States and the treaty country. Then we have the E-2 and the concept of substantial investment. Number one, the investor must have control of the funds, and the investment must be at risk. The investor must have received the funds from a legitimate source. The investment must be a real and operating enterprise, and it must be substantial, meaning it must be more than marginal. Now, the investor has to have received the funds from a legitimate source, and the consular officer will look at what is the origination of these investment funds. The investor must have control of the funds, and the investment must be at risk. There has to be an element of losing the funds. So generally, in the E-2 context, just having money sitting in the company bank account will not qualify for the E-2. They are looking at, the consul will be looking at whether the money has actually been spent on startup expenses. So for instance, if you're leasing or buying a premises, you're buying equipment, you're getting licenses, you've done a business plan, you've hired employees, all these things would count as spending the money, but the money just sitting in the bank will not qualify as being at risk. Now, the other concept is the investment must be a real and operating enterprise. So it must be actual, must exist, can't just exist on paper. For, let's say, a retail establishment or a restaurant, it's not good enough that the company has leased premises, but really the doors need to be open and be ready to operate in order to qualify for the E-2 visa. One of the big concepts is that the investment must be substantial. And so the specific minimum amount is going to be determined by what's called the proportionality test, meaning the investment must be substantial in proportion to the total cost of the U.S. enterprise. The investment should be sufficient to ensure that the operation of the U.S. enterprise can proceed. So for instance, let's say you're going to be buying a business, buying an ongoing business, and the cost of the company is $250,000, and you're transferring the $250,000, then clearly you've met the proportionality test by investing 100% of the requirement. But let's say the business is $500,000, and you're only putting down $200,000. So in that sense, the consul may have issues that there's the proportion there is too low. Now, there's no minimum investment amount that you will find in any law book or rule or in the Immigration Act as to what is the minimum investment. Just the key term, it must be substantial. is really going to be case by case based on the type of company or the business. Certain businesses might only cost $100,000 or $200,000. Other businesses may involve a bigger investment amount. The other concept is that the investment cannot be considered marginal. So consular officers will examine, does the income from the U.S. enterprise exceed the amount required of the investor to support themselves and their family? And they'll also look at the capacity of the U.S. enterprise to promote the U.S. economy and to create jobs for U.S. workers. Generally, the more money you invest and the more American workers that you can hire provides for a stronger E-2 visa application. The other concept is that the applicant themselves must be in a position to develop and direct the E-enterprise, meaning the owner or the company that owns the U.S. enterprise must demonstrate that it will develop and direct the enterprise. So if the owner is coming over and making the investment and wants the E-visa, they must be actively involved in running the day-to-day activities of the E-2 business. They can't be, set up a structure such that it's going to be a passive investment. They need to be very hands-on and direct the operations. Now, when the person applying for the visa is not the actual investor, they can be an employee, and it can be a supervisory, executive, or a highly specialized skill capacity. Ordinary skilled and unskilled workers will not qualify for the E-visa. To qualify as a treaty employee, both the employee and the employer must possess the same nationality of the treaty country that you're using. Now, in the instance that the U.S. company is owned by a foreign corporation, the foreign corporation must own at least half of the treaty country nationality. And if the employer is in the United States, the employer must be maintaining E-status for the company to qualify for E-employees. Now, we talked about qualifying capacity. Again, it's employed in a supervisory or executive capacity, or you possess highly specialized skills which are essential to the efficient operation of the firm. One other key concept is that the applicant must have the intent to return to their home country at the expiration of the E-visa or the E-status. You don't have to prove that you're traveling to the United States for a set period of time. You can even sell your house, move to the United States, and qualify for the E-visa. Basically, consular officers are looking for what's called an unequivocal statement from the visa applicant that they do intend to return to the home country at the expiration of the visa. Generally, this is going to be sufficient to satisfy this requirement. There are instances in terms of E-visa applicants being able to remain in the United States for 20, 25 years. We have clients that have renewed. They were able to get 5-year visas and have renewed 4 or 5 times, and their businesses have been viable, and they keep renewing the E-visa, and for whatever reason, they're not interested in U.S. permanent residence. So it is possible to keep renewing the E-visa as long as the business is viable. In terms of the procedure, there's 2 main ways that you can apply for the E-visa. One, if the person is already in the United States, and let's say a business visitor visa status, which is the B-1, you can apply for a change of status with the Immigration Service, or USCIS. Or, most commonly, the visa applicant can apply directly at a U.S. consular post. This is the more common procedure, as most of the time folks on the E-visa will need to travel frequently and need the visa and their passport to be able to travel back to the United States. Now, if you're here in the U.S. in status and you want to change your status to an E, you file a non-immigrant petition with the supporting materials with the Immigration Service. Average processing times right now is about 2 to 5 months to get some sort of adjudication from immigration. There is the option to upgrade to premium processing for an extra filing fee of $1,225. Doing that will get you adjudication in 15 days, The adjudication will be, in best case instances, an approval, or oftentimes it may result in what's called a request for evidence, asking for more information or documents to justify the application. If the Immigration Service approves the application, then the treaty trader or investor is allowed to remain in the United States during the period of authorized stay issued by the Immigration Service, which is generally going to be valid for a 2-year period. But if they do need to travel abroad, they will need to go through consular processing at a U.S. consular post. So in terms of applying at a consular post, number one is you generally need to schedule an appointment with one of the U.S. consular posts that handle the e-visas in your country. Typically, you have to submit the file ahead of time for review by the visa officer. Some consular posts require that the application be submitted electronically by email. Others, you courier in the packet. Others allow you to submit in person. And there are a few consular posts where you actually present the e-visa application at the time of the interview, and they make a decision right there during the interview. It does require the visa applicant to appear in person for an interview with the U.S. consular officer, where the officer will ask questions regarding the investment and the person's qualifications for the visa. Now, for instance, if you had the E approved by the Immigration Service, that approval from immigration doesn't go too far with the consular officers. They will look at it de novo, meaning they're going to look at it afresh, and just because the Immigration Service approved it does not mean that the consul will rubber stamp it. They will review all the materials as well. Now, processing times for e-visas vary depending on the location in the world. Some places will take about a month to 2, sometimes longer, and sometimes, for instance, in Vancouver, they have that pilot program where you can walk in and be adjudicated the day of your interview. Other places you submit ahead of time, and it could take weeks to months until they're ready to call you in for the interview. E-visas are issued according to a reciprocity schedule, and you can see the link here on the Department of State's website where you punch in your country, and you can see what the maximum period is for the e-visa. Generally, the maximum is going to be 5 years. But some countries have very short treaties for the visa reciprocity schedule. And so, for instance, Iran, you might get a single entry 90-day e-visa, and it just varies based on the country. But a lot of the Western European countries will have the maximum schedule, such as 5 years, or Japan has a 5-year maximum. Now, the Department of State does advise consular officers to issue the e-visas based on the maximum reciprocity permitted. But consuls do have discretion, and they do exercise their discretion. So it is always possible that you receive a shorter validity e-visa, especially if it's a startup business and not too many employees in the beginning. The consul might issue a 1- or 2-year visa and say, well, we want to see you back in a couple years so we can compare how the business is actually doing to what you projected in your business plan. So they do compare and see how on track you are. There's a concept called TCN processing, or third country national visa processing, where folks can apply at consular posts in Mexico or Canada for visas. Unfortunately, Canada does not accept TCN e-visa applications, although they do accept TCN applications for most other visa categories in the non-immigrant context. Mexico will allow you to renew your e-visa as long as the visa was issued before. So if you entered the United States in a status other than an E, changed your status to E, and you're applying for the first time, that's not going to be accepted at one of the 3 consular posts in Mexico that handle e-visas. For those that are renewing an e-visa, then you could apply in Mexico. It's kind of a 2-step process where you schedule a fingerprinting appointment for them to capture your biometrics, and you also submit the e-visa application, and then a couple of weeks later you get scheduled for the in-person interview. So to recap, the difference between status and the visa. The status, if you're approved by immigration, you can get 2 years, and if you want to travel outside the United States, then you do need to apply for your visa at a U.S. consular post. The visa can be issued for up to 5 years based on the country's reciprocity schedule with the U.S., and that would be if you consular process. And when you arrive at the U.S. port of entry, Customs and Border Protection, or CBP, generally will admit the e-visa applicant for a 2-year period, regardless of how long that e-visa is valid, as long as your passport is good for more than 2 years. So for instance, if you have 6 months left on your e-visa and you entered today, as long as your passport's good for the next few years, the CBP officer can admit that person for a 2-year period. Spouses of e-visa holders are authorized to work, and to get the work authorization, they do have to apply with USCIS for an employment authorization document. And that card would then allow them to apply for a Social Security card, and they could be employed. It's kind of a nice benefit for the spouse. They're a free agent with that EAD card, not limited to working only with the e-visa company. Allows them to work for any other company or even to work for themselves if they'd like. Children of e-visa holders can attend school, but they're not eligible for that work authorization process. And we talked about the intent to depart. There must be that intent to depart on termination of the E-status. You do not need to maintain your foreign residence while you're in the U.S. And that statement of an unequivocal intent to depart the U.S. is generally going to be sufficient to satisfy the intent. But the consuls in some countries will look a little bit more at this issue, but consuls can ask, have you ever filed for an immigrant visa petition? Has a company ever filed a labor certification for you? Do you have a family member that has filed a family-based petition, and how far out is the priority date? So sometimes if you've taken steps for immigrant visas, that could be factored into the equation. So how do you turn the E into a green card? Well, it doesn't automatically convert into U.S. permanent residence. There is the EB-5, which is the $1 million investor green card. Sometimes you can leverage your E-2 investment into the EB-5. The minimum is going to be $1 million investment, although if it's an area of high unemployment, the threshold would be $500,000. The key is that you would need to create 10 jobs for U.S. workers. There's also the concept of EB-5 regional programs. A lot of times this would be the lower amount, the $500,000, in a pre-approved program. And this refers to a pooled investment where the company is collecting investments from a group of investors, and those folks are applying for their green cards. So I prepared these charts over the next few slides which compare options for entrepreneurs. And you can see the different visa categories. The E-2, the L1, and the 2 different EB-5 categories. The E-2, what is the amount of investment? Again, it could be any amount, but usually you need to be over the $100,000, $150,000 threshold to have a shot at getting your visa. The L1, there's no minimum amount. With the regional EB-5, you need usually at least $500,000. The direct EB-5 is going to be $500,000 or $1 million. Must you create jobs? Well, for the E-2, the more jobs you can create, the stronger your case, but there are E-2 companies that have just a few U.S. employees. Same with the L1. For the regional center EB-5, there can be 10 direct or indirect jobs, and the direct EB-5 is 10 direct jobs. The investor's employment on the E, remember, manager or essential skills unless you're the investor. In the L1 context, the manager or specialized knowledge or an executive will qualify. The regional center EB-5 is a limited partner, and on the direct EB-5, policy-making individual. Time frames for the E, generally it's going to be weeks to months or sometimes more. The L, you have the option if you file with USCIS, is going to be less than 15 days with premium processing. You can see with the EB-5s, the regional, it's about 1.5 to 2 years sometimes to get through the process, and the direct EB-5 sometimes a year to 18 months. The procedures for the E, well, we talked about directly filing at a consular post or the option of filing with the Immigration Service. With the L1, definitely going to be with USCIS unless it's a large company. And then there's a blanket petition they can apply directly at a consular post. With the EB-5s, first the application is lodged with the Immigration Service. Once it's been approved, you would apply for consular processing, or if in the U.S. and the status, adjustment of status might be an option. Across the board, spouses are able to work. So on the E and the L, spouses can apply for work authorization. On the Regional Center EB-5s, once they're approved for the green card or they file for adjustment of status, then spouses can also apply for work authorization, as can children. Question of whether family or the investor can attend school. It's yes across the board. With a green card, they may qualify for in-state tuition at a sooner point. We talked about employment authorization for the E. So once the applicant gets their E visa and they enter the U.S., or if they're in the U.S. and they receive their status, they can apply. They'll be in E status, can apply for their Social Security, and can start working. With the L, same thing. If you have the visa, you enter, you're in L status, you can start working. With the regional centers, it's going to take a couple months till you receive your work authorization, and the same with the direct EB-5. The question is, can the investment that you use be a gift? With the E-2, it can be a gift. So a family member can gift you the money, but you still will have to trace the source of the funds, how they got the money, and if required, did they pay the proper taxes, gift taxes on that money? The L1, yes, and for the EB-5s, yes. Can the investment funds be a loan? Generally, enterprise cannot be used as collateral in the E-2 context. In the L1, it's a yes. In the regional center EB-5 and direct EB-5, it cannot be used as the collateral. Expedites are available for premium processing if filed with USCIS in the E and L context. Unfortunately, there's no premium processing with the EB-5s. The relevance of the country in the E, remember, only the treaty country and nationals of that treaty country can apply for the E. In the L, it's not relevant. The company can have a different nationality than the person applying for the visa. For the EB-5s, it becomes an issue just in terms of the source and the tracing of the funds. In terms of necessity of an overseas company, well, in the E-2 context, there's no requirement of an overseas company, although if there is an overseas affiliated company, there might be the option of later applying for a green card. The L1, yes. On the EB-5, no. Can you buy an existing company? On the E-2, it is permitted. The L1, yes. On the regional EB-5, no. On the direct EB-5, yes, but you have to add 10 jobs. Where can the company be located? Well, the E-2, the company can be located anywhere in the United States. So wherever you'd like to set up shop for your business would be fine. The same with the L. With the regional center EB-5s, to qualify for the $500,000 amount, then it's going to be a rural area of high unemployment. Same for the direct EB-5 if you want to get to the lower amount. For employment requirements, there's no prior employment required with the same company overseas. On the L's, there is a 1-year requirement and no requirement for the EB-5s. For the length of the visa, remember, with the E, it can be up to 5 years, and that's going to be based on reciprocity. The L is going to be a 1 year for startups. With the green cards, the EB-5s, you would get a 2-year conditional green card, and then you would apply for the full green card. And as far as the max, remember with the E-2, you can have unlimited extension. So as long as the company is viable, you can keep renewing E applications. With the L1, you will max out after either 5 or 7 years, depending on your category. With the EB5s, eventually that will lead to permanent residence. So that concludes the webinar. Again, my name is Avi Friedman. I'm a senior attorney here at Wolfsdorf. I've handled many e-visa applications and would be glad to assist if you do decide that you would like to apply for either an E-1 or an E-2. We're going to take a look and see if we have any questions from the audience. Right now is your chance to submit your question. We'll wait a minute to see if anybody would like to type in any questions. In the meantime, I refer you to our webpage at wolfsdorf.com. We have a lot of good information and articles on all the different non-immigrant visa categories, including the E-visa. If you are interested in some more technical details about the E, you're welcome to send me an email at avi@wolfsdorf.com or give me a call in the office at 800-VISA-LAW, and the direct line 310-570-4088. My extension is 249. I will wait one more minute to see if anybody has questions. And as I mentioned, if you do think of questions at a later time, feel free to reach out by emailing. If you do want a copy of the PowerPoint, you could let us know. We could send you a PDF version of the PowerPoint with all the key info. And if you're interested in a longer article that I have, just put that in your email, and we could send you some more information. Keep in mind that this presentation is not legal advice, and it is basically for informational purposes only. And if you have specific legal questions, then you should address them to us. So we do have a question, which is, can children of somebody who's on an E1 or E2 attend public high schools without being in F1 status? And the answer is yes. Children that are in E status are allowed to attend public high schools, and they can also attend public or private high schools. So that is permitted. Let's see. Here's a question on whether it's possible to get permanent green card with an E2 after a certain amount of time. Unfortunately, the E2 does not convert itself into U.S. permanent residence. There needs to be an extra step. So the E2, remember, it's a non-immigrant visa, and it's going to be based on the reciprocity schedule with your home country. If you're interested in U.S. permanent residence, you would have to either qualify by seeing if you could turn it into an EB5 by investing at least $500,000 or $1 million and having the 10 full-time U.S. employees, or to structure it such that there is a common affiliation between the U.S. company and an overseas company, and the person is coming over in an executive type of capacity. Let's see. There was a follow-up on the public school as far as tuition waiver, or must they pay tuition. Generally, if the public schools do not require tuition, then somebody in E2 status should be able to qualify, but I do recommend you consult with the public school district to confirm. Here's a question. Have you tried renewing E2 visas by sending the passports of the E2 visa holders in the U.S. consulate in Mexico if the E-visa was initially obtained in the treaty country? That's a pretty technical question, and I think we'd have to look at the specifics of the case to see if that particular individual might qualify for the interview waiver program that Mexico does have. Here's another good question. With regards to the investment type in E2, what kinds of investment will qualify? How about intangible investment, such as the investor service? Well, the service won't count, but if you have intellectual property, that can count for your investment. So for instance, if you have a patent on some technology, if you can get an evaluation or get it assessed and come up with an amount by an expert as to what the value is, and you're providing that to the U.S. company, you can count that towards investment. I mentioned some concepts of investment, money spent. So you spend money on leasing your premises or buying your premises. You buy equipment. You hire employees. You do some marketing. You deal with other professionals, accounting, legal. All of those will count for your startup cost. Let's see here. Another question, can I change from F1 to E2 while in the United States? And the answer is yes, as long as you're in status. If you're enrolled and you're in F1 status, whether as a student or on your OPT, you could file to change your status from F1 to E2. Remember, that's going to be the filing with USCIS, which can take several months unless you do premium processing. And in the event that you do decide that you'd like to travel, you will have to apply for your visa. Somebody asked the cost of the E2 application. There would be, if you hire an attorney, there would be legal fees. And if you apply, there's different fees, whether if you apply with USCIS or you apply the consular route. So if you'd like more details on the fees, you're welcome to send me an email, and I can tell you a general ballpark as far as what government fees and legal fees tend to be. Somebody asked, have you experienced an E-2 visa renewal in Mexico for a Mexican national where the ASC appointment was not required? No, I believe most folks are going to have to attend at a minimum the ASC appointment because at that point, that's where the package is submitted. Sometimes it might be possible, depending on when the biometrics were captured, to qualify for a waiver, and you might be able to have an agent submit at the ASC appointment. But again, it's very technical. We'd have to look at the dates of when it was submitted and the type of case to see if that might qualify. Let's see if there's any other questions. There's a question about, let's see here, the investment. Can the risk of the business be shared with a partner where I have the majority of the shares? For example, I have 51% and my partner has 49%. Yes, the answer is yes. Both can make some investment if there's a split in shares, although I would say $100,000 is pretty low, and they're going to look at and see whether that's even substantial, and they'll look at proportionality in terms of setting up the business. Here's a good question. Does the business have to be ongoing while applying for the e-visa? Can we show the business is being set up and we'll start operations once the investor is here? Generally, the e-visa has to be at a point where the doors are ready to be opened and will open once the visa is issued. In the context where you're buying an existing business, you can enter into an escrow agreement for purchase. The money can be sitting in the escrow account. The only condition can be that the visa is issued. So if the visa is issued, the money transfers hands. That's a little bit of a way to protect the investment money. Somebody asked again, specific to Mexico City, the U.S. Embassy in Mexico City, accepting applications by email and halting it. I don't have any additional details at this time when they're going to reinstate that process. I would say just check with the Post website. And they do have an email. If you look on their website, you can get their email and ask them as well. So let's see if we missed any questions. We'll go through the list real fast. Looks like we got everyone's questions. Here's one last one that came through. What is the refusal rate with the E-2? It really depends on, the case. We don't necessarily keep the statistics, and Department of State might post some statistics on E-2 approval rates and denial rates, but really it's going to be country specific and it's case specific in terms of what was the reason for the denial. Some countries are historically more lenient on e-visas than others. Every country has a different sort of threshold in terms of what they want to see as a minimum investment level. So, we can evaluate what you're thinking about in the E-2 context and give you our thoughts on a particular consular post as to whether you would have a viable case or not. So last chance for questions before we sign out. And again, if you do have further questions later on, you're always welcome to send me an email. So we'll wait another 15 seconds to see if anybody else has questions. So at this time, I'd like to thank everybody for joining us for this E-1 and E-2 visa presentation. Again, my name is Avi Friedman. If you have any follow-up additional questions or you're interested in learning more about the E-2, please do get in touch with me. We'd be glad to assist you in applying for an e-visa if that's something you'd be interested in. Again, the email, avi@wolfsdorf.com, and our toll-free number is 800-VISA-LAW.